in this really important discussion and presentation about our courts, which, I mean, I just never understood how important they are for our liberal democracy. I think we're going to have a good discussion. I will, before I turn it over, I will say that we are going to be marching on June 14th for No Kings. And I know the courts will be important in making sure we don't have a self-proclaimed king. So please join us. All the information is on our website. And with that, I will turn it over to Ori to lead and moderate this discussion.
Well, thank you, Judith, and thank all of you for joining us. I am truly privileged and honored to be able to moderate this discussion regarding one of the most crucial issues facing our city and our country with two tremendously prestigious lawyers, Colleen Connell and Carolyn Shapiro. Colleen is the executive director of the ACLU Illinois. Carolyn is a law professor at the Chicago-Kent College of Law and the co-director of the Chicago-Kent Institute on the Supreme Court of the United States. So let's get started with these two, again, very important people that will give us very important information. Colleen, when it comes to upholding justice, the ACLU has been our boots on the ground. So please tell us what the ACLU lawsuits have been directed at preserving our constitutional liberties and rights, thus preserving our democracy through the courts.
Thanks, Ori, for the question, and thank you all for the invitation to participate tonight. Since January 21st, the ACLU has filed more than 100 legal actions challenging various executive orders and other actions of the Trump administration. A number, I think, bear or warrant specific mention. Ours was the first lawsuit challenging the executive order that sought to eliminate natural-born citizenship, a right that is specifically guaranteed under the 14th Amendment to the Constitution. We have also filed a host of actions challenging Trump's efforts to ramp up deportation efforts without any process whatsoever, let alone appropriate due process for people who are in this country under a variety of different circumstances and legal status. And one of our major pieces of litigation in this area has been a challenge to the Trump administration's attempt to use the Enemy Aliens Act to deport summarily people from who are, from different countries who are immigrants here. And our arguments under the Enemy Alien Act is that basically the act, which was an 18th century enactment, was intended to be used only if there was either a declaration of war by Congress or an actual invasion of the country from a foreign power. And to state the obvious, neither such circumstance is present here. And we have had some real success in the courts of really at least temporarily blocking the Trump administration's efforts to use the Enemy Aliens Act to deport migrants without any process whatsoever. To collapse a pretty complex piece of litigation and distill it down, the courts have basically said you have to afford some notice and some due process. And then the ACLU also has a number of actions dealing with the actual deportation of people, again, without process, to CCOT, the infamous prison in Central America. Most notably, I think, have been the litigation surrounding the deportation of two migrants who were who were deported inappropriately, and as the Trump administration has acknowledged, by mistake. But we have yet to actually see the Trump administration respond appropriately to the court orders directing the Trump administration to facilitate the return of these two immigrants to the United States. And that is potentially setting up one of the matters or issues that keeps me awake at night, and I'm sure Carolyn awake at night, and probably every lawyer or most lawyers in this country. What are we going to do if the Trump administration moves from what has really been slow walking compliance with court orders to actual defiance of court orders? And I want to flag briefly for folks that in the new budget bill that went from the House to the Senate last week, there is a provision that attempts to restrict the use of the contempt power by federal judges, and basically says that federal judges cannot hold folks in contempt or issue sort of broad injunctive relief unless they require the posting of a financial bond to protect against any adverse impact that those court orders would have on the government. And just to contextualize this a little bit more, historically, civil rights organizations like the ACLU have not been required to post bonds when we sue the government and seek declaratory and injunctive relief, or even seek contempt, because of the fact that the courts have basically concluded that even if public interest organizations have not ultimately won on the merits or succeeded on the merits in a final judgment, these lawsuits are in the public interest. And that oftentimes an injunctive order is just preserving the status quo, and the government suffers no real harm, the way, for example, a private litigant might suffer harm if the court enjoined a private litigant from continuing to do business, for example. So that's just sort of a quick introduction to some of the litigation that the ACLU has brought over the last 4.5 months. And if you want to just take a step back, big umbrella piece, our goal here really is to use the courts in their historic role as called for in Article 3 of the Constitution, which is the article of the Constitution that establishes the federal judiciary, to actually do their job, which, to quote, the first Chief Justice John Marshall, is essentially to say what the law is. And we are attempting to get the courts to essentially recognize the constitutional rights that are protected in the Constitution itself or under federal law, as, for example, the immigration law. So I'm going to stop there. Ori, happy for follow-up questions, but also want to hear your great questions and Carolyn's great answers.
Well, thank you, Colleen. And I'm going to, as a lawyer, I'm not going to interrupt because we lawyers talk a lot. So I'm just going to moderate and try to stay on target so that we can have questions and really enjoy not enjoy, but discuss the merits of this conversation. Carolyn, given the historic structural dismantling that Colleen just talked about and that they're addressing of our judicial system, as a law professor, how are you teaching and encouraging future lawyers to understand what's happening now and yet remain committed to becoming lawyers? Carolyn?
You're muted. She's muted.
It's kind of insane that what are we more than 5 years into our all having to learn how to do this, and I still forget to unmute myself. So first of all, thank you all for the invitation, and I really want to also thank the ACLU, and which is just taking the lead in so many ways in protecting our constitutional democracy. And Colleen, I don't even know if I've told you this, but my co-clerk and dear friend, Cecilia Wong, has become the National Legal Director, and I'm so proud of her. And anyway, that's a little bit of inside baseball there. So now I'm going to answer Ari's question in the classic law professor way of saying, well, I can only answer that question. Ari, I can see you're already laughing. I can only answer that question if I say a bunch of other things first. And so let me say a couple of things. I think it's really important in this moment to think about our constitutional structure and the role of courts in that constitutional structure. And I want to preface what I'm about to say by saying I don't personally believe that there's one best way to structure a constitutional democracy. I think there are good arguments for different, parliamentary system, our system. I'm not trying to make an argument about that, but I am making an argument that we have a system and it's designed to do certain things, and we should care about that, and we should pay attention to what that system is designed to do. So a big part of it, of course, is along the lines of what Colleen was talking about, which is that courts are there in part to protect the individual rights of not just citizens, but anybody who lives who is present in the United States from abuses against other government actors. And I think there's a whole thing that we weren't asked to talk about, but I just can't help but just putting aside in brackets, which is the complete abdication of the congressional role by members of both parties, frankly, for a long time, but especially right now by Republicans, but not. I don't put all the blame on them. So you may all have learned in school that we have a separation of powers system with 3 branches of government and the federal government of the states and checks and balances, and that's all there. The framers thought to preserve liberty. I mean, they kind of thought, because their definition of liberty and who was entitled to it was not our definition of liberty and who's entitled to it, but that was the basic theoretical concept. And you might even have been skeptical about that. Like, right, why do we need 3 branches of government in order to protect liberty? And on that point, again, I'll bracket are there other systems that would work as well or perhaps even better? And in fact, this is partly what my students tell me. My students say to me, like, I make them learn. I've been making them learn now for a number of years about things like the appointments clause, and the non-delegation doctrine, that that doesn't mean anything to folks who aren't lawyers, or even folks who are lawyers, don't worry. You don't need to know for purposes of what I'm going to say, but they say to me, like, I get on my evaluation sometimes, I don't know why she made us learn that. And now I'm getting emails from students saying, I'm so glad you made us learn that, because I understand what's going on. I understand why it matters, and I can explain it to other people. So that's one thing I'll just say in terms of my teaching my students. I care a lot, not just about what they understand, but about what they are. I think lawyers are ambassadors. We are ambassadors to the rest of the world. I say this to my students and they start laughing. Like my first year students, how many of you have had family members or friends ask you to help them understand what happens when you get a traffic ticket? Not like help them fix it, just like, what am I supposed to do? And they all start laughing. Or how many of your family and friends are asking you to explain what's happening in the news? And they all start laughing because of course that happens. And so I want them to be able to answer those kinds of questions. Okay, so the point of all of that is to say that right now, courts are being asked to police the separation of powers. And this is distinct from the individual rights stuff that Colleen was talking about, which is also incredibly important. But courts are being asked to police separation of powers considerations, and in particular, the scope of executive power, I think as never before. I'm not a historian, so I don't want to say that with 100% confidence, but certainly, as you know, in the lifetime of anybody on this Zoom. The executive is attempting to do things that, for example, eliminate agencies and programs that Congress created by law. Congress created by law, and either a president signed that law, or much less likely it was overridden, a veto was overridden, almost always a president signed it. And the way you repeal something in our country is you pass a new law. So the executive isn't supposed to just be able to say, you know what, I don't like that anymore. I'm just not going to do it. So courts are being asked to police that. And likewise, Congress is, or courts are being asked to police when the executive says, you know what, Congress says the government is supposed to spend some money, Congress appropriates the funds, but we're just not going to do it because we don't want to. I think we've taken for granted for decades, probably a century or close to a century, that the executive branch is committed to the Constitution, committed to the constitutional project, and will act in good faith. And what we have right now is an executive that is not acting in good faith. This executive is attempting to seize power and upend the entire constitutional system. So I'll just say, and I'll say a little bit more about that in a moment. But I want to just add, I think probably everybody on this call is aware, this has got significant real world implications. Full disclosure, I represent a group of an association of USAID workers. The destruction of USAID, which was the first thing that this administration attempted to do, is completely, in my view, unconstitutional and illegal for the reasons I've already said. Congress created USAID. Congress has appropriated funds for very specific purposes, fighting tuberculosis, PEPFAR, fighting malaria, et cetera. The government is just refusing to do. So hundreds of thousands, millions perhaps of people have already died, are dying, are going to have AIDS. I mean, it's genuinely horrific. But beyond USAID, and I'm kind of obsessed with USAID since I have clients, and also it's USAID. The destruction of the knowledge infrastructure even more broadly, the attack on scientific research, both government research and government funded research, I think, that's going to, there are going to be consequences of that probably for at least a generation. All right, so all of that's doom and gloom. I think I'm probably not saying anything you all don't know. So let me talk about what that means for courts. The first thing it means is that when somebody like me goes to court and says, hey, the executive branch is doing this thing that's unconstitutional and illegal for these structural reasons, right? Like the executive isn't allowed to shut down an agency Congress created. The executive isn't allowed to refuse to spend the money. The first thing that happens is that there are a bunch of really complicated and technical legal issues about things like jurisdiction. But beyond those complicated and technical issues, which lawyers are busy litigating, there's a bottom line issue, which is that courts actually don't want to be in the business of running agencies. And, there was a time, I think, when they were more willing to do that. And there are still some courts that are doing that in places, but they really don't want to do that. And the Supreme Court is unlikely to bless federal district court, a federal trial court saying, you know what, I'm going to come in and run this USAID, or I'm going to come in and run NIH or whatever. That's not something courts really want to do. And courts are also moving and in part for that reason, courts are moving very slowly and very deliberately in these cases involving the kinds of executive actions I'm describing. There is only, as far as I know, only one fully briefed and argued appellate court case raising these issues. There's lots of appellate court action involving emergency relief or requests for emergency relief. But the only case that I'm aware of that's been fully briefed and argued has to do with the Consumer Finance Protection Bureau, which Congress created and which the administration said, yeah, we don't want that anymore. And the trial court in the District of Columbia said, yeah, you can't do that, but was very deferential to the executive about exactly what that meant. And there's been a lot of, I'm not going to get into the technicalities, but the case was argued in the Court of Appeals on May 16th, and we don't have an argument yet, an opinion yet. Some of the reasons why I think courts are moving very slowly which I think are important for us to think about. I think there are at least three reasons. One is what I've already said, this concern about, wait, I'm a court. I don't know how to run an agency. I don't want to be in that business. And related to that are the two others. And the two others, they could be all seen as, different sides of the same coin, or three sides of a coin. I don't know. One is a fear of defiance. The administration and the types of cases that Colleen was talking about, I think it's fair to say is not complying and is defying court orders, but is pretending they're not. They're kind of sidling up to that line. They're lying about what they're doing. They're lying to the public. They're lying to the courts. In some sense, I think that's good in that they seem to think that, good is a relative term here, but they seem to think that if they announced outright, we're defying the courts, that wouldn't go well for them. And I'm going to come back to that idea. But it's also we're now a little bit, I think, like the frog in the water, the boiling water, in that, okay, fine. So they say they're going to do this, or they, I think there's a certain amount of fatigue around, okay, now what are they going to say? Now, I don't mean for the lawyers. I think the lawyers are relentless, including the ACLU lawyers. But just in terms of the public response, okay, fine. They're just not doing what they're supposed to do. And the other thing, and this is, I think, perhaps maybe the most controversial thing I'm going to say, is fear of reversal by the Supreme Court. And I actually think the Supreme Court is part of the problem of overall our ability to protect the courts as a whole. The Supreme Court, we have these district judges appointed by members of both parties who are being, I think, very careful. I don't think they're perfect, but they're being very careful. They're being very deliberate. They're not moving with incredible speed. And nobody really knows what the Supreme Court is going to do. And that's because there are at least 2 or 3 justices who basically seem to think anytime somebody says no to Donald Trump, it's a national emergency. And there are at least 5 or 6 justices who believe in a version of something called a unitary executive, which is, in my view, a deeply misguided understanding of the Constitution that says that the president has a kind of authority that, in my view, is equivalent, or not maybe entirely equivalent, but not that far off from a king. And just bookmark the king, because I'm going to come back to that idea. But we don't know for sure. We really don't know for sure what the Supreme Court is going to do. And because there's only been a handful of cases that have made it that far, the court has been pretty reasonably good on cases involving due process for people who are being disappeared to gulags in El Salvador, which I would, I wish that were like a given that we could say, of course they are, but right, they've been reasonably good on that. On some of the types of cases I'm talking about, they've been, they're actually, the tea leaves are extremely hard to read. There are a couple of different cases and they're not clearly consistent with each other. Okay, so that's my background. Now I'm going to finally answer Ori's question. Like, what do I tell my students? What I tell my students is constitutional interpretation and application is inherently political and contested. It has been for the entire existence of our country. And we are all allowed an opinion on what the Constitution means, how to interpret the Constitution, how to apply the Constitution. And just to be clear, I think originalists, which I am not one of, should actually embrace that idea, because for decades, more than decades, a century and a half at least, originalism was not a thing. And originalism became the dominant mode of interpretation of the Constitution because of political persuasion. I don't agree with it. I think it's wrong, but we wouldn't have it if a lot of people hadn't worked so hard to persuade a lot of other people that it was the right way to interpret the Constitution. And so those of us who aren't originalists, it's on us to do that next. The second point I want to make, and I say this to my students as well, is that courts inherently don't have a lot of power. This is not a unique thing that I say. Lots of people say this. They don't have the power of the purse. They can't control armies. So what matters in terms of judicial power is what the rest of us think. What do the rest of us think about courts? And that is part of what happened, say, during the Civil Rights Movement, when we had people in the South, white people in the South, who were unwilling to comply with court orders, and Eisenhower sent the National Guard. Other court marshals, judicial marshals went out, US Marshals did things. It required people beyond judges to say, no, this matters, and we're going to make sure it happens. So again, what matters is what we collectively believe. And there's a lot of evidence that Americans overwhelmingly think that the executive should follow court orders, or at least Supreme Court orders, calling back to what I said before about how we don't exactly know what that's going to look like. All right, this is all consistent with what scholars of authoritarianism say. I am not an expert in this area, but I've read a lot of experts. And what they say is that how do you defeat authoritarianism? You defeat authoritarianism by people. You don't defeat authoritarianism through a court or through any in particular institution. Especially, once authoritarians have gained the kind of power that they have in our country. So the way we can resist is by is people power. And so when I talk to my students about the courts and how they should think about the courts, what I really want them to understand, and I think, things are happening fast, and I haven't taught constitutional law since before January. So, what I say next time I teach it is going to be a little different. But what I think matters is, what is your vision of our institutional and constitutional structure? Courts are courts, right? Courts can do good things, courts can do bad things. We want the right kind of, right? So what we care about is defending the Constitution, defending our constitutional order. And courts are part of that. And I think it's a bit of a mistake to kind of pull courts out and say, well, we have to follow what courts say no matter what, no matter whether they're, because I can imagine a world in which we might say, you know what, I'm going to protest that court order. I don't think that's right. I'm not advocating that in this moment, but I think we have to be committed to the Constitution. And as a lawyer, I took an oath to the Constitution. All of us did when we were sworn in, which brings me to coming back to the point about kings. You know, the origin story of the United States is this, which I'm sure we're all familiar with, is this, you know, we had King George, he was a tyrant, he was telling us all what to do. None of the people on this call probably would have had much say one way or the other at the time, but he was telling us all what to do, and the colonies revolted because they didn't want that kind of tyranny. They wanted what they called at the time a republican form of government, which meant some kind of representative democracy and no monarchy. It meant different other things to different people, but those were the two primary things it meant. No kings. It's hard for when I teach con law, I tell my students on the first day that almost every view is welcome in the classroom, and I give them two examples of things that we're just not are not up for debate. One is monarchy, and the other is chattel slavery. Those are not up for debate. I'm not gonna indulge those. And I say that not because I think anybody's actually gonna make those arguments, but because in part, because I wanna make it clear that saying all views are welcome doesn't mean really all views are necessarily welcome. And also, and I wanna reserve the right to say, you know what, you've gone too far. No kings. That's a fundamental premise of our country. And on June 14th, you can put all these ideas together by joining the No Kings Day protests, which also June 14th also happens to be the day that there's going to be this really obscene military parade in Washington, D.C. that Trump has ordered on his birthday. Unless you know, in case you thought we lived in North Korea. We can fight back. We should all go out there if we can. We can find other ways of supporting the No Kings Day protest. But also I'm gonna end with this. That protest is only one. Nothing is going to change. Nothing will be resolved. We won't be able to recover our democracy and our rule of law with one day of protest. This is going to be a marathon. And I personally, I spent a lot of time thinking about people like Harriet Tubman and Frederick Douglass and Charles Hamilton Houston, people who devoted their lives to a vision of democracy and liberty, and some of whom did not live to see the fruits of their labor. And if they could do it, I'm way more privileged and comfortable than they were. I would like to think we all can. So I'm going to end there. I've been talking for a long time. I'll stop.
Well, you got your 20 minutes in. Thank you, Carolyn, so much. And all of what you said, I used to be a retired civil rights attorney, but as you just said, given what's going on, Colleen knows I'm working harder for free now than I did when I was getting paid. So, but it's, you know, what we need is the continuance of that. Can I, before we go into any Q&A in the chat, I want to go back to what Colleen talked about, and it was called the One Big Beautiful Bill that had over 1,000 pages in it, kind of like the Project 2025, and the part that the one provision, the one sentence, the devastating sentence that really means if the Senate passes it, it means the courts that the Trump administration does not have to adhere to the court's decision. One, to both of you, do you think the Senate will pass this bill? And if so, what are the consequences? What can the courts do, and what can we, as we move into action steps with Carol, what can we as the people do?
I think you actually asked me that, and then I didn't write it down. I had my notes, so I went through my notes, so I failed to answer it.
Well, Colleen mentioned it, so, you know, Colleen, you can speak up if you.
Yeah, so the quick answer is I don't know if the Senate is going to sign off on that. It's really hard to get a bead on, from my vantage point, and what's really going on. You know, there's been a lot of discussion about whether that provision regarding the power of the courts is actually, quote unquote, related to the budget, which is one of the requirements for a budget reconciliation bill. But Thune, who is the majority leader of the Senate, has shown a willingness to override the Senate parliamentarian, and who concluded, a couple weeks ago, that the provision regarding the California requirement that all vehicles sold in the state by 2030 or something like that, 2035, must be electric. The Senate parliamentarian ruled that that provision was not related to the budget and was inappropriately considered, as part of this discussion. And Thune was willing to override that. And so I'm a little concerned that Thune will also override the parliamentarian if she decides that the provision regarding the courts is not budget related. As to the impact, I would prefer obviously that this not get included or enacted. But as I read the language of the provision, it gives judges some room to say, okay, I've got to set a quote unquote reasonable bond to protect the government from the costs of compliance with an order that might ultimately be overturned. And I think that lots of judges can find good reason to either impose no bond or such a de minimis bond that civil rights organizations like the ACLU can meet that. But that, I will just own, is in some ways a very elitist approach to it. Of course, the ACLU can afford that. We are an organization with boots on the ground in every state, and we like to pride ourselves with having been built for moments like this. We have created a corporate structure and reserves to allow us to litigate as effectively as we can. But for, perhaps an individual immigrant who may be represented by a solo practitioner in the immigration space, a bond that might be de minimis for the ACLU could be very difficult, if not impossible, to meet. So, I think we have to be very conscious of the real risk of, impact that may not be as notable on large organizations like the ACLU as it might be on individual litigants. But overall, I think what is so objectionable about this bill is its threat to the constitutional structure that Carolyn laid out so quickly and so finely. It's it is another example, not just of this president not operating in good faith, but really for the Republican members of Congress not acting in good faith, because on the issue of nationwide injunctions, which is really what's motivating a lot of this legislative churning. Uh, the the Republicans have been notorious for going to Judge Kaczmarek in Texas to seek an injunction that is in so many instances at odds with both the facts and the laws. I mean, his Judge Kaczmarek's rulings have almost routinely been overruled, even by the very conservative Fifth Circuit, in which he sits, and so I think it's just really evidence of the president and the Republican members of Congress not operating in good faith. And, going back to another point that Carolyn raised about the importance of concerted action by the public, the people power to speak. There's an emerging set of data, both from nationwide polling, but also from polling that we've done here in Illinois, that the public is not responding well to the fact that the Trump administration is breaking the rules. They see this as destructive of our democracy and really, quite frankly, wrong. And I'm not talking about the, the diehard MAGA folks who, you know, just to be perfectly blunt, I think act as though they're part of a cult. But, run-of-the-mill Americans, even people who may have voted for Trump, even, our neighbors in downstate Illinois who are very much part of the red part of the state, people are by and large rule-abiding. They recognize that the system really only works if most of us follow the rules most of the time, and that it's really dangerous to everyone if the powers in government do not follow the rules like the rest of us are required to. And they really do see this as having profoundly negative impact on our country and potentially everybody's lives. And so I think we have to work with that sentiment. We have to really communicate to folks that they get it in a very profound way. And we need to show up at the No Kings rally on the 14th. We need to do all of the actions that we've all talked about, many, many times of being good citizens and engage, doing a lot of civic engagement. And that means showing up at congressional town halls. It means writing our elected officials and our members of Congress, even if it seems that we or our elected members are in the minority, which they are right now in Congress. And remembering, to both encourage them to follow their better angels, to quote Lincoln, but also to thank them when they do stand up and do the right things, because it's really important that our elected officials who do the right thing feel the public support for showing the spine that so many have not. And while we're on the issue of spine, I mean, the courts, by and large, I'm going to echo Carolyn, have been proceeding very carefully, but in case after case, I think really making a good faith effort to understand and apply the law, which in many cases is pretty straightforward given the audaciousness of what the Trump administration is trying to do. And I think we need to figure out a way to express both public support for judicial independence as opposed to weighing in on one decision or another, and great public opprobrium and condemnation of the acceleration of threats against the federal judges. I just read today, and I'll probably not quite get the numbers precisely right, but in the 5 months preceding January, there had been 80 threats against federal judges. In the 5 months starting in January and going through until, really this point in time, so I guess it's been 4.5 months, the number of threats against federal judges has increased threefold. And that's just not acceptable. Because there are a lot of people out there who see the efforts of the Trump administration, and I'm going to shout out Stephen Miller by name, who have taken it upon themselves to identify the judges by name and who appointed them, and in some instances, identify the communities where they live. And I mean, that is like a green flag go to a lot of people to act in ways that are very threatening and ultimately violent. And we've seen that here in the Northern District of Illinois, where not all that many years ago, federal judges husband and mother were murdered in her home by an unhappy litigant. And so I think we have to really take into consideration how high the stakes are, and really build on the reality that there are more of us than there are of them. And we have to make our our views known, not in a threatening way, but in a firm and concerted way. We know the difference between right and wrong, and I mean, at a certain level, with all due respect to Carolyn's and my, just absolute love for the rule of law and the judicial opinions. At the end of the day, this really reduces down to basic right and wrong.
And Colleen, I hate to cut you off, but we do have some questions in the chat, and I'd like for you to be able to
Yep.
respond to some of the people here who may have some really will help you even go further. So Carol, you want to turn that over? And thank you, Colleen, so much.
Yeah,
I'm
what I,
just gonna say, oh, I'm sorry. I thought you said Carolyn.
no,
Go ahead,
go
Carol.
ahead.
No, Carol's
Carolyn,
got
you
questions.
go ahead and then I'll get to questions.
Okay, I'm gonna just say three things really fast. Number one, I agree with four things. Number one, I agree with everything Colleen said. Number two, on the bond, the issue of bond, I think it is an unknown what the courts would ultimately say about the constitutionality of that provision. If the courts felt, and really the Supreme Court felt, that it was too big an incursion on the ability of the courts to assert their own authority, it's possible they would say it's unconstitutional. I don't want to predict that that's what's going to happen. But I think that's at least a possibility. Number three, I'm going to say today in the New York Times, at least the print version of the New York Times, which I still get at my house, there's an article on the op-ed page by David French talking about Trump's reaction to judges, and also I think Stephen Miller's reaction to judges, and talking about how the attacks on judges, and just this over the weekend, the attack on the Federalist Society and Leonard Leo, who like really Trump should consider his best friend, might actually backfire in terms of how judges are likely to react to those kinds of attacks. And then finally, I'll just echo the last thing Colleen said. It's not, I mean, the value of the rule of law is incredibly important. The values of the Constitution are incredibly important. And all of those things are only as strong as the people supporting them. And I know, I mean, I assume that many of us, or many of you like me, are kind of exhausted and scared and see an incredibly long road ahead and don't know how to get, if we're going to make it to the end. And I'm just going to say, we're going to have to pass the baton. I mean, I actually say this to my kids who are in their 20s, like, this is going to be the work of your life. I'm really sorry we're leaving you this mess, but it's our job to take this as far as we can. And that means, like, after June 14th, things aren't going to be fixed. So I want everybody to come out on June 14th, but then I don't want people to be upset the next week when it's like, well, things aren't fixed. They're not going to be fixed on June 16th. We are in this for the long haul.
Thank you so much, Carol. Carolyn, now Carol with the questions, Q&A, please.
What I tried to do is sort of group some of the questions and pull from some of the comments what I think are questions from folks in the audience. As we do this, if you have other questions, put them in the chat and I'll try to integrate them in as we go, if my brain can do more than one thing at one time. Let me just say, though, I've done some background in my own work from Courts Matter, Illinois, on a lot of this. And I just thought it was interesting as both of you were talking. I found a piece that went back and looked at authoritarians and their backgrounds and things like that, and how they approach the courts. And it looked at Italy and Berlusconi, and Erdogan in Turkey, and Mugabe in Zimbabwe, and Duarte in the Philippines, and Bolsonaro in Brazil. And the interesting thing was, in this piece, they said something different happened in Israel in 2023. And it said, and this is a quote, when Benjamin Netanyahu's coalition tried to destroy judicial independence, people from all parts of society took to the streets. A broad, nonpartisan group came together to defend democracy and resist authoritarianism. And I just thought, okay, so we have the 14th, the March on the 14th coming up as a first step, not as the end, but as a first step. And it sort of spoke to me, as both of you were saying, that's a beginning. And we have history to back us up. So maybe that's one of the ways we'll go. So let me get to some questions. One of the first questions that came up was about the restrictions on contempt. And the question, really, the essence of the question was, does that make a court order meaningless?
Well, I think I would say the same thing that I said about the bond issue, that, and I actually think the contempt issue is more likely to be struck down by the courts than the bond issue, because it really does go into the inherent power of the courts. So, yeah, I mean, if the courts can't hold somebody in contempt and can't, send the marshals to put them in jail, the courts have really I mean, that's not great power, but it's in terms of, the power of the purse, the power of the army, whatever. So I don't want to be overly optimistic, but I think that's more likely to be struck down than the limits on bonds.
Yeah. Do you want to add anything to that, Colleen? Okay. I'm wondering, because this is sort of piecing together a question from some comments about whether or not the Supreme Court is part of the problem. You both have said that the district judges are being very careful and really moving carefully, slowly, and following the law as it's written. And SCOTUS is moving with much greater speed than the lower courts. What does that say for the future? Are we going to have an administration that's only turning to the Supreme Court?
I think that is a real risk, Carol, but it's also something. I mean, I think that the Supreme Court's rulings, and I really appreciate Carolyn's view of this, have often sort of been on procedure and procedural due process, and have kicked the can down the road or kicked the can back to the district courts for the ultimate ruling on the merits, which will then go up again through the appellate court and ultimately to the Supreme Court. And that is not so out of ordinary with what we have seen before. But the alacrity with which the Supreme Court acts, I think, is also a reflection of the fact that, the Trump administration has been sued so often, like a multitude of 10, in terms of, the number of lawsuits against the Biden. I think it's probably a multitude of 20 in terms of the lawsuits, for example, against the Biden administration in the first 5 months. And so it's a little unclear how all of this is going to really shake out. But I think the Trump administration has shown a great propensity to rush to the Supreme Court because, Trump's made no secret of the fact that he, quote unquote, considers it his court.
Yeah, I agree with that. I think it's hard to say at this point, really, what role the Supreme Court is going to play. I mean, they've done some things that I think were deeply misguided, most notably the immunity decision. It's the only decision I've ever told my students I don't know how to teach, and I teach lots of decisions that I think are wrong. But I think it's wrong at a kind of, genetic level. I don't know how else to put it. So they've certainly done a lot to contribute to the situation we're in. But I genuinely don't, and I assume, well, it's already true, but I assume it will continue to be true that they will issue opinions and orders that I personally think are wrong. But I don't know what the overall trend will be, and I just think it's too soon to say.
If I can just briefly expand a little bit on what Carolyn is saying, I think that I personally, both as a lawyer and as a citizen, can live with many decisions that are wrong because we can find ways, to square them with other cases, or we can see a path toward narrowing their application and their impact, except for cases like the immunity case, which I felt and continue to feel threaten the very constitutional structure. I think it is a decision as ultimately harmful of our constitutional democracy as the Dred Scott decision was. Because it so fundamentally distorts both the precise language of the Constitution in terms of immunity. The framers knew how to create immunity. If they wanted to do so, they did that. For example, for debates that occur, on the floor of Congress, they decidedly rejected the concept of sort of broad executive immunity because they didn't want to create a king, and for the court to actually disregard the language and the structure of the Constitution, which specifically empowered the legislative branch as the most powerful branch of the three branches of government, and which both by language and intent sought to confine the power of the executive, is extremely damaging to our constitutional structure, and has been seen and treated by Trump himself as a green light to do whatever he wants to do, because he is unafraid, at least at present, of any judicial consequences.
So let me ask you about whether or not you see in what is happening the real suppression of media and information, and the how can I say this, the promotion of disinformation happening, or is that just also being out of proportion in terms of what we're hearing?
So I think the answer is yes, yes, and no. I think that there has been efforts by the Trump administration to really suppress coverage of its actions by their efforts to bar, for example, the Associated Press from the White House briefing room, the way in which they conduct the briefings. But I think that the press, unfortunately, has acquiesced and been complicit in the efforts to suppress. There was no outcry by the White House Correspondents Association, by the efforts of the White House to bar the AP. And the continued coverage of the Trump administration it makes me want to shriek on a daily basis. In terms of they continue to, sort of, they covered, but it's sort of like, well, he's just being brash, or he's just being bold, or he's really good at, manipulating, the message or controlling the message. And they never want to talk about, the huge impact on our constitutional democracy, or in so many instances, the real impact on people. So I think there has been suppression. I think there's been self-suppression. I think we are seeing that, just to point to CBS and what, the producer of 60 Minutes has done, and the fact that so many of the staff of the newsroom of CBS have, really, reported being chilled by the fact that Sherry Redstone is being very explicit about her desire to settle the defamation suit that Trump brought against 60 Minutes, claiming that its interview of then candidate Kamala Harris was distorted and defamatory. And I mean, media law experts across the country basically say this is a suit that is destined to fail. I mean, it is just stupid. And the fact that, she wants to settle it because she wants the her big merger to be approved is just, an example of the media ownership muzzling, sometimes explicitly, sometimes in a variety of ways, their news sections. And I would put Jeff Bezos as paying Melania Trump $38 million for her biography in that same category.
I again, as always, agree with everything Colleen said. I'll add three things. One is along the same lines as what Colleen said about Paramount and CBS and Sherry Redstone, which is outrageous what's happening. I would put in a similar category, Jake Tapper, who they actually generally don't hate as a reporter or interviewer. But I think what's happening right now with his book and his promoting this whole story about, I mean, CNN is all about how the Biden and the Democrats were hiding Biden's, decline. And, I mean, I don't think if to the extent it's true, I don't know. It's not important in this moment. It's not important. And he wants to sell a lot of books. And I just find that insane. So another criticism I have of the press, and this is something that I think this is a kind of thing that letters to the editor might make a difference on, is the press will often report things that Trump does as Trump did X. For example, Trump issued an executive order that says that elections are going to be run a certain way. Well, you know what? Trump actually doesn't have the power to do that. The president doesn't have the power to do that. And executive orders allow the president to tell the executive branch what to do. And that means they have to be within constitutional or statutory authority. Now, obviously, there are going to be debates about exactly where those lines are. And there are some things I think he doesn't have the power to do that ultimately the courts might say he does. But running elections is not one of those things. And the sort of credulousness with which the media reports, oh, he says he's doing X, therefore he's doing X, and maybe they'll say, well, some people disagree. I think that's really problematic. The upshot of all that, and what Colleen was saying about Paramount and CBS, is I think it's incredibly important for those of us who care about truthful reporting to support nonprofit and independent media. So, I mean, I personally am a member of ProPublica. I support individual journalists, some of whom, like Chris Geidner, who's a really outstanding legal reporter who has a Substack. I wish it wasn't on Substack, but I'm nonetheless, I'm a subscriber. I think that kind of information is crucially important. And it actually doesn't take that many of us to support somebody like Chris Geidner, right? Like, a 50, a couple, 10,000 people paying him $100 a year is a lot, he can probably run his Substack pretty well that way. So I really strongly encourage you to support that type of reporting.
Let me get to at least one other question. One of our attendees would like to know, have you addressed the issue of surveillance, which apparently is a part of the big, beautiful bill. That's all in quotation marks. I hope you understand that. And if surveillance is something that's going to be part of what becomes law, and we're all encouraging everyone to go to this march on the 14th, should we be concerned about being surveilled? And is that something that should be in the back of our heads?
I think I wouldn't be concerned about being surveilled at the marches on the 14th. Much to the ACLU's chagrin and objections, the city of Chicago has long had surveillance cameras in lots of public spaces, and that has not stopped people from coming out and protesting. I think there is safety in numbers, and I would urge people, to come out and and really, quite frankly, protest. And if people are concerned about being surveilled, I don't know what the weather's going to be like on the 14th, but wear a hoodie. And I think that there are ways, or all of us who still have a good supply of COVID masks, wear your mask, and maybe even print a message on your mask. So I think I would say that would not be the top of my concerns. I think the risks to our democracy are bigger by not showing up.
I agree with that. I'll just say that, there are people, of course, who have individual circumstances. I mean, if a person is themselves undocumented or even documented, but not a non-citizen, I mean, I think people have to make individualized judgments along those lines, and I don't. But I mean, when I said I take comfort in thinking about people like Harriet Tubman and Frederick Douglass and Charles Hamilton Houston, I mean, this may sound very self-important, and I really don't mean it to. It's how I try to approach the moment we're in. I get scared, but I spent my adolescence and young adulthood reading Holocaust literature. I mean, that was kind of like the thing Jewish women my age did. I don't know how else to put it. I read a lot of Holocaust literature, and the question the thought bubble that I make myself put up above my head is, why did you do that? What was the point? And so I don't mean to suggest that there aren't reasons to be worried, and there aren't. I agree with Colleen that I think the immediate concerns for people who are American citizens and frankly who are white are not nearly as extreme as they might be for other people, and I would strongly encourage you to go out but to the extent that we have fear, and I don't think it's irrational to have some fear, what's the what are we doing here?
If I can just briefly expand on that and tap into one of the other questions that was in the chat box with respect to the law firms. Sherilyn Ifill spoke at the ACLU's big lunch in April, and she said that she addressed the issue of the executive orders against the law firms and some of the law firm pushback. And she said, you know, so many of my friends at some of the firms that acquiesced have called her and said, oh, you wouldn't believe the pressure. You wouldn't believe, you know, the risks that we're facing. You know, it's really awful. And she said, I say to them, this is nothing like the risk that, you know, the people who spoke out against Jim Crow felt. This is nothing like the risk that Thurgood Marshall, that Charles Hamilton Houston felt. Those original lawyers were shot at. They risked lynching. They were imprisoned in Southern jails with no process whatsoever, just for trying to register people to vote. She said, that's real risk. And, you know, I think it is really important that we um, uh, confront the risk that is real and our own fears. And, you know, I want to be able to say, because I agree with Carolyn, that we will have to pass the baton, you know, that I did what I could.
We also had a question that I think is on the minds of those of us who have been a part of and are as part of Chicago Women Take Action nonprofit groups, and whether or not the supposed attacks on nonprofit status under this both big beautiful bill and other aspects of this administration are possibly viable aspects of what could come down the pipe. Your thoughts on that?
I agree. The provision that made it through is a little less threatening than some of the earlier versions, but I think it's still problematic. I think it could and probably will be challenged. Um, and I will just say that, you know, the ACLU, both our national office and many of us affiliates, have spent a lot of time, you know, not just over the last 5 months, but really in preparation for this, of making sure that our house is in order with respect to compliance with, you know, employment laws, 990s, things like that. But I think these provisions are very harmful. We opposed it when it was um, introduced in the last Congress, or there was a very similar provision. You know, I think it really does weaponize potentially you know, the use of the government and the pulling of tax exempt status from organizations on the basis of their speech or their viewpoint. And I think ultimately that is one of the reasons why the First Amendment likely will hopefully prevail.
Pretty much covered the essence of most of the questions that are in the chat, and I apologize to those who have put questions in and feel we didn't get to them.
Carol, I hate to interfere, but you know, as a lawyer, I must ask these lawyers, what do you think about the question in its mind, the attack of law firms that Jenner stood up for, but some are not? What does that mean for the legal profession, particularly given what we're facing now? And I'm done.
Well, I think the thing that makes me, gives me some hope around that. I mean, it's appalling. Let's just start. It's appalling. And those firms that caved are cowards. I mean, not every single person at those firms, they've, you know, I think there's a lot of internal pushback. But I got no defense of what they did. But I just read an article yesterday, about how there are a bunch of big clients who are ditching those firms. I know Microsoft ditched one of them to go to Jenner specifically for this reason. And that's true for both, you know, sometimes I think there are clients that are doing that because they don't like Donald Trump. But also I think there are clients that are doing that are like, well, I'm sometimes adverse to the government. Like, how will I know that my lawyer is going to be willing to to fight the administration on my behalf? So I think those firms, in particular, those firms that proactively did this without even having an executive order against them. I think that was extremely misguided. And I think, I mean, it's hard, I don't like to make predictions because, it's hard to say at anything in this unprecedented moment, but it seems to me that it's not going well.
Thank you.
Or do you want me to?
Yes, now we're going to close with action steps that,
Can I interrupt? There is one question in the chat, if you could just quickly address. And it's about, if you could just talk a little bit about the ongoing and upcoming work of the Trump administration to voter suppression and what role the courts may play in that. Because that will be very important, I think, for us.
It's disturbing, and during the course of this Zoom, I got a text from a colleague who said that the Supreme Court accepted cert on a case out of Illinois, which involved the
Mike Buck's case.
Illinois mail-in ballot case. As you may recall, Representative Mike Bost, or Congressman Mike Bost, challenged the Illinois Vote by Mail Act that allows ballots that were mailed before Election Day to be counted, even if they are received after Election Day. The district court judge essentially laughed the case out of court, and it's now been taken for appeal. So I think it is something to be concerned about, not just because of the voter suppression efforts by Trump, but because this court has not shown itself to be protective of the right to vote. And I would go back to, Chief Justice Roberts' Shelby County decision in 2014 or 15, whenever it was, in which he basically gutted the Voting Rights Act of 65. And so, again, I think that we have to continue to fight on all fronts in this.
Times have changed.
And it's things like this that make the upcoming election in 26 important,
Yes.
because there have been efforts to reinstate the voting rights, what was gutted in the Voting Rights Act. But until we can count on the legislature, it's not going to happen. So, yeah. And just so all of you know, there are still 33 more cases that the Supreme Court has heard. They heard 62 cases this year. There are 33 that we haven't had any decisions on. So in the next probably month or less, we will have 33 decisions on cases from this Supreme Court. So something that, of course, I will be following. I don't know about the rest of you. So let me first, on behalf of Ori and me, thank Colleen and Carolyn for a really informative and really useful evening and information that I think all of us can be mulling over. I want to leave us with what I'll call a call for action, but it's really a call for future action. One of the things that we can do is take the time to let our senators know how we feel about the appointment of judges to lifetime positions on the federal courts. Trump just made his first set of nominees for those positions. There are, wait a minute, it's 6 that he made. 1, 2, 3, 4, 5, 6 that he just made this past week. And I haven't had enough time to do the research on all of them. But I'm going to, my call for action, with permission from Chicago Women Take Action, is that everyone on this call, if you don't go on your own, I will be sending you a link to the Courts Matter Illinois website, where you can sign up to get our action alerts. When these nominees come before the Senate Judiciary Committee, either they will be voted on to go before the full Senate for a vote. And if they go before the full Senate and are voted in, they are lifetime judges on the courts. You've just heard today how the lower courts, and this is part of that system, have been very good for the most part in following the law and that sort of thing. We want really good judges on those courts. What we do at Courts Matter Illinois is send alerts for you to call your senators and tell them to vote yes or vote no on these judges. So now that we are starting to get nominees, it's going to be very important to stay on top of them and inform our senators how we feel about these judges. And if you have friends and family in other states where it may be even more important to inform senators on these votes, to share that information with them. So if you go to www.courtsmatterillinois, Illinois is spelled out fully, .com, you'll get to our brand new website and you can sign up yourself, or I will be sending you a link in the next few days where you can sign up and get our alerts. And that's my call to action. And I want to thank everyone for being with us, and especially thank our speakers and Ori for chairing this.
Well, thank you
Everyone have a
all.
wonderful evening.
Thank you all.